Victor? Hey, can you test the Spanish part and see if I can hear you? Okay, well, I'm on the Spanish channel also, so we should be good.
Your name?
Thank you.
That's the charge. That's the.
Which one is going to be started?
You're trying to get your job back. Take. So that's why.
Mr. Abraham, I'm just waiting on Ms. Grisham.
Okay, Your Honor, we're testing the Spanish.
All right, good afternoon, Mr. Montelongo. How are you? Hey, I'm doing fine, Thank you for asking. Mr. Montemore, if you'll go ahead and raise your right hand, I'm going to place you under oath. Sir, do you solemnly swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you. And if you can go ahead and identify yourself by name and license number. Thank you, sir. All right, court calls. Cause number CR 11-105. My docket says Elpidio. I don't know if that's supposed to be Elpidio, Hernandez. Mr. Schmidt, can you help me?
Yeah, it's Elpidio.
Elpidio, okay. Elpidio Hernandez, and I show that we're set for arraignment today, and the record will reflect that Mr. Montemayor is providing the translation services today. Go ahead, Mr. Schmidt.
Judge, I would just notify the court that I was able to meet with Mr. Hernandez a week or two ago with my interpreter, and we went through what we have so far. So at this point, his name is correct on the indictment. I understand as we started. We will wait when we're reading that. Enter a plea of not guilty. Ask that it be carried for a pretrial hearing.
All right, the court will find that Mr. Hernandez has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record, and the court will set this matter for pretrial hearing. Do you want something a little further back than March 7th, Mr. Schmidt?
At this point in time, Judge, I can tell you that I've received the written discovery, but none of the digital, and given the age of the case, I'm not certain what the status of that is. So I intend to meet with the DA's office on Friday on this and other issues. At this point, I'd ask for the March 7th date with leave court for an additional pretrial if I can't get what I need by that.
You want to set it out and just go ahead and do March 28th?
We can do that, Judge, if you'd like. The issue that we have, or that I intend to meet with Mr. Hernandez again on this Saturday with an interpreter as well, if he's still in custody, to discuss some of these issues. The other issue is that obviously that Mr. Hernandez is eligible for a bond, and he does have an ICE hold. So, you know, in the event he was to bond out, then we would have to change gears a little bit. So I'm trying to expedite these things as quickly as I can, just so that we can get a resolution.
Okay, well, court will go ahead and set it for Tuesday, March 7th for pretrial hearing. And let's set that for 2 p.m. and Ms. Tabraham will schedule with the Office of Court Administration to see if we can have an interpreter available on that day.
Yes, sir. And if we could have the interpreter explain to Mr. Hernandez that he's about to sign his reset notice with that date.
And Mr. Montemayor, if you can ask the defendant if he has any questions, if he can bring it to our attention at this time with your assistance.
Cuando venga el sábado, él va a traer alguien que hable español.
Mr. Schmidt, you want to answer that?
Well, yeah, I'll have a Spanish speaking translator meet with him and myself on Saturday to discuss these issues, assuming he hasn't posted bond by then. In addition to that, I've instructed him to have his English speaking family member contact my office tomorrow at 9 a.m.
Ask him if there's any further questions.
No, por el momento no.
Okay, then the court will see Mr. Hernandez on March 7th.
Okay.
Mr. Montemor, are you also doing our 2:30 with Mr. Montelongo?
I have him here, Judge.
Okay, good. Good, all right. Court cause number CR 15-279, State versus Pablo Montelongo. And the court will identify Mr. Victor Montemayor as the licensed a language interpreter for the court, who has previously been placed under oath and remains under oath at this time. I show that Mr. Montelongo is set for arraignment. Mr. Schmidt, go ahead.
That is correct, Judge. And same announcement, I met with Mr. Montelongo with an interpreter a weekend or two ago and discussed his case. As far as the indictment is concerned, his name is spelled correctly, he understands his charge. He'd enter a plea of not guilty and wait formal reading of that. Ask for pretrial setting.
You want that March 7th date?
Yes, sir, I do.
Okay.
In addition to that, if the interpreter could relay to Mr. Montelongo that I've been in negotiations with the DA's office, and we have followed up on some of the information that he provided to me, and I believe that we're at the point where we have a resolution that he will want to accept, and I intend to meet with him this Saturday with an interpreter as well.
And will you ask Mr. Montemor, or will you ask Mr. Montelongo if he has any questions? Okay, court finds that Mr. Montelongo has entered his plea of not guilty. The court will put that into the record. The court will set Mr. Montelongo for pretrial hearing on March 7th. And we'll set that also at we'll set that at 2:30 p.m. All right, and if there's nothing further, then Mr. Montelongo's excused.
¿Cuánto es la fianza?
Mr. Schmidt, do you know? I haven't looked this case up.
I didn't hear the question.
Mr. Schmidt, can you hear?
No,
No,
You can't
sir.
hear?
no, sir.
He's asking if there's a bond in this case, a bail.
There is a bond. In my recollection, it's $100,000. And I would ask Mr. Montelongo to meet with me on Saturday prior to making any attempts to post that. I have spoken with his family members pertaining to the same as well. So I think that after we speak on Saturday, we may have a resolution.
Okay.
Yeah.
All right. Is that all you have with us today, Mr. Montemor?
Yeah.
Ms. Abraham, do we have any other need in the jail Spanish speaking today?
Not to my knowledge, Your Honor.
No? Are you, and Ms. Abraham, are y'all on the English channel?
No.
In Zoom, are y'all clicked over to the English channel? I think.
No.
All right, so Mr. Montemor, I appreciate you being here. I appreciate your assistance to the court today. That appears to be all that we have. We'll give you your 20-minute break, and I won't tell anybody at OCA that we're still not translating. I'll tell them there's a 20-minute lag time. Have a good one. Thank you, Mr. Montemor. All right, do we have any other attorneys that are ready?
Mr. Ashmore's ready on this late.
Good afternoon, Mr. Ashmore.
Afternoon, Your Honor. Spies, Mr. Woodwine. Judge, we're here on Susan Louise Lee.
All right, this is CR 22-151, State versus Susan Louise Lee, and it's my understanding that there's a plea agreement in this case, Mr. Ashmore.
There is, Judge.
And I think I have it here. I've got a copy.
Okay, if you have it, it's there's two cases. There's a burglary of a building. This one is the CR 22-151, and there's a companion DA 22-0112, both of which are going to be, one is 1245, one is 1244, with a time served consuming all of Miss Lee's 176 days in the county jail. She will have a $1,500 fine, court cost of $290, reimbursement $620. I have explained to her that she needs to report to the courthouse within 1 day to pay the balance of her financials, get on a payment schedule. And we're asking the court to review and hopefully approve that agreement.
All right, Ms. Lee, raise your right hand. I'm going to place you under oath. Ms. Lee, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Susan Louise Lee, is that correct?
Yes, sir.
And Ms. Lee, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Casey Ashmore. Are you pleased with his representation of you?
Absolutely.
Do you feel like you've had enough time to talk with him about this case and have all your legal questions answered?
Absolutely. Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
And where you signed, you're telling the court that is your true and correct signature.
Yes, sir.
And you heard Mr. Ashmore inform the court as to what the plea agreement is. Is that your understanding?
Yes, sir.
And I have to admonish you that burglary of a building is a state jail felony offense. That if prosecuted under section 1244A of the Texas Penal Code would mean that you would be convicted today of a felony offense, but you would be punished as a class A misdemeanor offense, which would carry a range of punishment that could not exceed 365 days or have a fine of more than $2,000. Do you understand that range of punishment? Okay, and I see the plea agreement under 1244A would be, as Mr. Ashmore said, 176 days in jail. You would have credit for all that time already served. You would be ordered to pay a $1,500 fine plus your court costs, plus reimbursement fees of $620. And the DA's office would be dismissing the burglary of a building case. So understanding that range of punishment, understanding the plea agreement, you still wish to go forward?
Yes, sir.
Okay, so Ms. Lee, I would ask you, how do you plead to burglary of a building?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
In other words, you're not pleading guilty just so you can get a time served deal and get out of jail.
Oh, no.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the state's evidence?
No, Your Honor.
All right, the state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
I'm muted. Judge, we are in victim compliance. I do believe this has probably been sent to the court for a victim impact statement.
Well, I'm not aware. Let me see. The only victim impact that I have is regarding Aaron Alvarez. Let me see if there's something else. I don't have. Was it sent today?
I'm not sure, Judge. I can check.
The only victim impact statements I received today were for Mr. Epperson, Mr. Gurley, and Mr. Alvarez.
Judge, if we could pause this very briefly and I can go figure out what happened with that. I believe there is a victim impact on this and I need to make sure that the court reviews that prior to pronouncing sentence.
Okay. All right. So Ms. Lee, just go ahead and have a seat for just a moment and then we'll resume your plea in just a few minutes. Okay.
Yes, sir.
We have any other attorneys that are ready?
Are you ready, anybody?
No need. 10 minutes.
Mr. Spencer, give him 10 minutes,
Are you ready?
5 minutes left.
5 minutes.
Mr. Pruitt said he's just about ready.
I'll give him 3.
Yes. Now I recall. Yeah. We're gonna do this. Back on. I can tell. Okay.
Judge, Mr. White's ready when you are.
All right, court calls CR 2141, State versus Ivan Rostro Garcia. And is this for plea today, Mr. White?
That's correct, Your Honor.
All right, and I don't think I have any plea papers over here. Can someone tell me what the terms of the plea are?
Well, I've got the plea papers in front of me. What we are here on is a motion to adjudicate and revoke community supervision. We had 7 allegations, 7 counts. We are prepared to plead true. We have been in negotiations with the district attorney's office. We have been offered and accepting 6 months state jail facility. There's no fine, there's no restitution, there's no court cost. We have 3 days credit towards that 6 month state jail sentence.
So Mr. Rostro has already paid the balance of his financial obligations from the underlying case.
I'm assuming so. I will put it this way, we made an effort between the initial arrest and this court date to fix any of the allegations we possibly could. And some of those were financial.
Mr. Woodwhite, did you hear my question to Mr. White regarding the agreement? He said that the agreement is the defendant's going to plead true to 6 months state jail, 3 days credit, and he's already, I guess, paid the balance of his financial obligations. Are you showing any money owed towards supervision or fines or court costs or reimbursements?
Judge, our agreement was 6 months in the balance of his financial obligations. If the paperwork says that he doesn't have any balances, then I would read into that he is paid in full. I have not checked myself as to any balances. Again, my legal assistant contacts probation, the clerk's office, and figures out what the probationer owes. But I don't know, and I don't believe I have any real way of checking to see.
That's fine. Mr. White, so looking on the judgment where it says fines, court costs, those are all zeros?
That's correct, Your Honor.
No reimbursements, no restitution, no fine, no court costs?
0 fine, 0 restitution, 0 court cost, 0 reimbursement fees.
All right, then, Mr. Rostro Garcia, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, you can lower your hand. Let me see here. I'm going to. Can you see that document, Mr. Rostro?
Yes, sir.
All right, so it says here that you appeared before the court on November 12th, 2020. You pled guilty to the state jail felony offense of possession of a controlled substance, affiliate group 1, less than 1 gram. The court heard the evidence, found that there was enough evidence to convict you, but the court deferred a finding of guilt and placed you on community supervision for a period of 2 years. The court also assessed a $2,000 fine. And it was during your period of community supervision that the state filed this motion to adjudicate and revoke on July 5th of 2022. And they alleged multiple counts, those counts being counts 1 through 7. So there's counts 1, 2, and 3, and counts 4, 5, 6, and 7. You feel like you've had enough time to go over this motion to adjudicate with your attorney, Mr. White?
Yes, sir.
And are you confident that you've had the answers to all of your legal questions given to you?
Yes, sir.
And is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And are you happy with Mr. White as your attorney?
Yes, sir.
All right. And so at this time, Mr. Rostro Garcia, let me ask you, understanding the plea agreement that Mr. White indicated, which he said you were going to play true to these counts, and the state's recommending to you the minimum sentence in this case, which is the minimum of 6 months, that range of punishment being a minimum 6 months up to a maximum 2 years. The plea agreement is the minimum 6 months with you receiving 3 days credit towards that sentence. Is that your understanding of the plea agreement?
Yes, sir.
All right. So let me ask you, sir, how do you plead then to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not true?
Yes, sir.
Or are they, you gotta say true or not true?
True.
True. And are you telling me that each one of these counts is true because in fact, what they alleged is in fact true? You're not just saying that so you can get a plea agreement?
No, sir. Very true.
All right. Court will, well, let me ask you this. Has anyone threatened you to make you feel like you've had to plead true to anything today?
No, sir.
All right, court will accept the defendant's plea of true to each count as alleged. Mr. White, any objection to the admission of the defendant's waiver of rights and plea of true to state's motion to adjudicate?
No objection, Your Honor.
All right, that's admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, it would rest in peace.
Anything further from the defense?
Nothing, Your Honor.
All right, so court will find that Ivan Rostro Garcia was placed on community supervision, that he has violated the terms and conditions of his community supervision. Court finds all 7 counts to be true. The court will impose sentence pursuant to the plea agreement today. Court hereby revokes the community supervision of the defendant, sentences him to 6 months confinement in the state jail division of TDC, and awards him 3 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Rostro Garcia, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. I'm going to have you step over with the deputy to be fingerprinted. And then once you are released, well, actually, I guess you don't know anything. So once you're released, then your obligation and debt to society will be fulfilled.
Thank you, sir.
Your Honor, I believe that's all I have today.
Thank you, Mr. White. Good to see you. Mr. Woodwhack, you need luck on that victim impact statement?
Yes, Your Honor, I emailed it to Miss Tabraham to show you, and I forgot she's at the jail. I will email it to Miss Barker, and perhaps it will then get sent to you unless there's a better way for me to send it.
Miss Abraham is back here now. So if you email it to her, she'll probably bring it down just a moment. Do we have anyone else in jail that's ready?
Mr. Smith's coming on.
You don't like next, sir?
Cody White?
Cody White. CR 21346. Oh, is this a plea today, Mr. Schmidt?
It is a plea, Judge.
Can you walk me through the plea?
I will. Mr. White intends to plead true to the state's motion to adjudicate And the state has offered that upon plea of true that his community supervision be revoked, that he be sentenced to 7 months in state jail. And then assess the balance of his financial obligations, which appear on the judgment as $1,500 in fines, $180 restitution, $425 in court costs, and that he has 205 days credit.
All right, Mr. White, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. White, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thanks. So you can lower your hand. All right, Mr. White, appears that you were before the court on June 16th of 2022. You pled guilty to possession of a controlled substance, a penalty group 1, less than 1 gram, a state jail felony, which carried a range of punishment of not less than 6 months in prison or more than 2 years in prison. The court found that there was enough evidence to convict you, but the court followed your plea agreement on that day. The court suspended a sentence, deferred a finding of guilt on your case, placed you on deferred community supervision for 3 years, and ordered you to pay a $1,500 fine. It was during your community supervision period that the state filed this motion to adjudicate. Appears to have been filed October 11th, 2022. And they have alleged, and it appears to be 8 separate counts of ways that they believe that you have violated your community supervision. Have you had enough time to review this motion to adjudicate with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt's representation of you?
Yes, sir.
And the paperwork that you've read over and signed today, you understand everything that you've read and signed?
Yes, sir.
And you understand that Mr. Schmidt, having read the plea agreement to me, that's what you're asking the court to approve today. Is that correct?
Yes, sir.
All right. So, Mr. White, I'm going to ask you at this time, how do you plead to counts 1 through 8 as alleged in the state's motion to adjudicate? Are those counts true or not true?
They're true.
And are you telling me that each one of those is true because, in fact, each one of them is true? You're not just saying that to get a certain plea agreement?
That's right.
All right, court will accept the defendant's plea of true to each one of the counts alleged by the state in the motion to adjudicate. Mr. Schmidt, any objection to the defendant, to the state's evidence supporting the defendant's plea?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest in peace.
Anything further from the defense, Mr. Schmidt?
Nothing further.
All right, then based on the evidence before the court finds that Mr. Cody D. White was placed on community supervision. And during his community supervision, he violated the terms and conditions of his community supervision. The court finds all 8 counts alleged by the state to be true. The court will follow the plea agreement that Mr. White has reached with the state. Court hereby adjudicates Mr. White's guilt, convicts him of possession of controlled substance in penalty group 1, less than 1 gram. The court revokes his community supervision, sentences him to 7 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations, and awards him 205 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. White, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you get out of TDC, you'll need to report to the courthouse, make arrangements to pay off the things that you owe. Otherwise, a warrant will be issued for your arrest. Okay.
Yes, sir.
All right. Step over there, Deputy Everett. Anyone else, Mr. Schmidt?
Yeah, Tasha Messick.
Tasha K. Messick, CR 2185.
Judge, thank you. Ms. Messick, I don't know how much the court can recall, but We have an agreement with the state, and ultimately Ms. Messick's family members are coming up with a final balance of her outstanding financial obligations. I've been in contact with her husband this morning. It's his what he tells me is that he has the money, he's waiting for it to clear from the bank account so that he can come up here, meet with me, and then pay that. We've reset this a couple times, I understand, but we'd ask him for one additional reset for that money to clear so he can pay or come up here and pay on her behalf.
My recollection is that once he satisfied that there was going to be a motion to withdraw and terminate. Is that correct? Or is that not? Okay. So if that's in fact done, we wouldn't need to have another hearing for Ms. Messick, correct?
That's correct.
So I can set her for March 7th rather than Thursday. And if she gets it, if he pays today or tomorrow, then court could sign the motion to withdraw or sign the order to withdraw and terminate. Is that correct?
Yes, sir.
Okay, all right, then let's set Ms. Messick then for a motion to adjudicate on 3/7. And if that gets taken care of between now and then let me know and I'll get that order signed and she'll be released.
Yes, sir. Thanks.
All right, who do you want next, sir?
Ronald Tall.
Ronald Darren Toll, CR 21-146 and CR 22-297 for docket call.
And Judge, I met or spoke with Mr. Woodwike on Mr. Toll's case yesterday, and he relayed an offer. I have not relayed that offer to Mr. Toll yet. Anticipate doing that in the next couple of days. I think at that point we were likely to have a resolution. So we'd ask that it be set either for a docket call or a plea on the March 7th date.
All right, court will set Mr. Toll for docket call on March 7th at 1:30.
Yeah, I got Richard Shivers.
Richard Ray Shivers, CR 22-364.
You make it?
Yeah, I'll bet that. I need to go with me.
I hear you. Just have to see right next year.
All right, Mr. Shivers is set for pretrial.
That's true, Judge. We don't have any contested pretrial. I spoke with Mr. Woodwike. I believe we have an agreement on Mr. Shivers' case. We would like, if the DA's office is able to prepare the paperwork, to have him done on Thursday.
Okay. All right, court will set Mr. Shivers to enter plea on March 9th, Thursday of this week. I'm sorry, February 9th.
I've already put March on, I think, everything.
What's difficult is those months have, except for the short month of February, all the dates are the same. 7th, 9th, 28th.
Yeah, you're next.
Who'd you like next?
Bobby Evans.
Bobby Lynn Evans, CR 22-271. Mr. Evans is set for pretrial, I believe.
That's correct, Judge. At this point, we don't have any contested pretrial. I think that with some additional clarification, we probably have a resolution on Mr. Evans' case with the state. I can tell the court that I've been informed that Mr. Evans is, his father is actively in hospice and not expected to survive much longer. What I'd like to do on Mr. Evans' case is set him for Thursday with Mr. Woodwike and see if we do have a final resolution and hopefully get him taken care of no later than Thursday, so that he can get out and move on.
Mr. Woodward.
Judge, I don't have any objection to setting it to Thursday, and then Mr. Schmidt and I can see if we can work a resolution by that time.
All
But I
right,
think
all right, court will set Mr. Evans for docket call on March, on February 9th, Thursday. Who's like next?
Edward Drummond.
Edward Joseph Drummond, CR 22373. Pretrial.
That's correct, Judge. At this point, we don't have any contested pretrial issues. We'd ask that it be set for docket call on that March 7th date.
All right, the court will set Mr. Drummond for docket call March 7th. 30. Who's next?
Matthew Coleman.
Matthew Coleman, CR 22268, docket call.
Judge, we're going to ask for an additional docket call. I have a meeting scheduled with Ms. Heisel on Friday morning to discuss Mr. Coleman's case and see what happens from that.
You were looking for the March 7th date again?
Yes, sir.
All right, court will set Mr. Coleman for a final docket call on March 7th. 1:30. We need a few minutes.
Yeah, just give us a few minutes.
Okay.
Judge, are we ready on Miss Lee?
I haven't seen anything on a victim impact statement.
Yes, sir.
Oh, let's do one over here.
We had our shit together.
I don't know.
I mean, what the,
Are you being punished?
I guess so.
What's the big impact?
Who gives a fuck?
No.
None of the shit got taken and the other guy was doing the stealing. So who cares? Whoops. Excuse my defense attorney opinion.
All right, Deputy Everett. Are you in there? Can you go ahead and unmute? All right, Mr. Ashmore, you ready on Mr. or on Miss Lee?
Yes, Judge.
All right, Miss Lee, come on back up.
Yes, sir.
All right, let's see. The court has reviewed the victim impact statement that was provided by the state. I can't remember where we were in the plea, so let me just start here. So, Miss Lee, I've already placed you under oath. I do recall that. You understand that if I follow the plea agreement in your case today, that you will be a convicted felon, but you will be punished with misdemeanor sentence at 176 days in the county jail. You'll receive credit for all 176 days of time served. You'll receive a $1,500 fine plus court costs and $620 reimbursement fees. Do you understand that?
Yes, sir.
All right, and so I'm not sure if I asked you before, but how do you plead to burglary of a building, a state jail felony under section 1244A of the Texas Penal Code?
Guilty.
Are you pleading guilty because you are guilty of committing that offense?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
The court will accept the defendant's plea of guilt. Mr. Ashmore, do you believe Ms. Lee to be competent to enter into this plea agreement today?
Yes, Judge, we've spoken several times, over the telephone, in person here at the courthouse. And she's in all respects of sound mind and understands what we're doing here today.
Do you have any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of Ms. Lee's judicial confession. Anything further from the state other than the victim impact statement, Mr. Woodward?
No, Your Honor, we had rest and close at this time.
All right, the court will let the record reflect that the victim impact statement filed by Mr. Dylan Weatherford has been reviewed by the court. Court, having reviewed the evidence, finds that there is sufficient evidence to convict Ms. Lee of this offense. The court will follow the plea agreement. In this case, the court convicts Susan Louise Lee of a state jail felony offense. Court will assess her sentence under section 1244A of the Texas Penal Code at 176 days confinement in the county jail. Court issues credit for 176 days of time served. Court orders Ms. Lee to pay a $1,500 fine, $290 court costs, $620 reimbursement fees. The court awards 176 days credit towards that sentence for time served. Ms. Lee, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released, you need to report to the courthouse to make arrangements to either pay off all of the financial obligations that you owe part of this plea agreement. If you
Yes,
can't call off, then you need to meet with the court collection officer so that you can make arrangements on payment plan to discharge what you owe. Failure to pay what you owe, even through a payment plan, will result in the court issuing a warrant for your arrest. Do you understand that?
Yes, sir.
And you also understand, Ms. Lee, that burglarizing someone's building, going onto their property, going into their home, you understand that that is a very risky thing to do with your life. You understand that? You understand that Van Zandt County residents have guns in their homes and they're not afraid to use them. And people that walk onto other people's property just all the time are shot and killed. You understand that?
Yes, sir.
You understand that Texas provides a defense to people when their homes are being burglarized and they feel like their safety is being threatened. You understand that someone could be justified for taking your life because you walk into a building or a home or on a property, and if they feel like they're being not their property, but they feel like they're being threatened with their personal security. You understand that that's the risk you take.
Yes, sir.
All right, so if that happens to you, I'm not going to lose any sleep over it because I've told you. All right, go over your remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. See if you never get fingerprinted.
Yes, sir. Thank you.
Have me excused, Your Honor.
Yes, thank you, Mr. Ashland.
Oh,
We can put a bond amount. Yeah, but I didn't remember looking to see what it was. Thank you.
Mr. Schmidt, are you ready on anyone?
Not yet, sir. We don't have,
Okay,
wait.
that's fine. You can mute if you need to.
I
No, you're
promise you.
rowdy over there, so.
Fixing to go on a rain.
What the world is here?
Mr. Schmidt,
Yeah,
one quick question.
yes, sir.
I've got and I need you to speak in code, okay?
Got it.
No, listen, just look at your phone.
Uh,
I have a bet going on and between me and the honorable Stella Grisham.
Whatever it is, I'm innocent.
Oh, no, well, you're definitely not innocent of this.
I'm pretty sure
Nobody
I am.
Now, listen, I say, we have a soda pop. I'm not, we have a soda pop, online here. It's online. And so, I said Trace, Stella said Quattro.
The honorable judge would be correct. But I'm done now. I'm done. I think I'm good this time.
Oh, I think you're way good. I think you're way done.
Yeah, I beat the record already. My record.
I think you moved so far up the line that, you've reached the top for yourself. You're way out of your league.
But I think everybody knows that she's got me beat quite significantly.
Yeah, that's true.
She said, yeah, that's true.
That's what I thought.
That and a line for me.
All right, good. Well, Mr.
Are you ready, Mr. Schmidt?
Mr. Pruitt.
All right, let me get back over here to Mr. Pruitt. Mr. Pruitt, how are you doing today, sir?
I'm doing fine, sir.
All right, you're looking better, looking well. All right, this is cause number CR 2245. I believe it's just a status. Mr. Schmidt, go ahead.
Judge, it's my understanding it's status on competency. I believe that we had a report deeming Mr. Pruitt incompetent, and I'm not certain that he may be on the list, but I don't know the status of that as far as restoration is concerned, but it's my understanding you're getting some meds.
Yeah, I went to Andrew Center. I went to Andrew Center. I'm on my meds now. I'm focused. I look good.
Feeling better?
I feel better.
Okay.
It was just a thing with the medication and, but I'm good.
Okay, good. Good. Okay. And right, Mr. Schmidt, I don't know what the status is on the wait list for that from Mr. Pruitt. I did have reports that Mr. Pruitt was working with the jail staff over there, the nurses, that he was taking his medication. They've been giving me a lot of good reports on Mr. Pruitt, saying he's willingly and voluntarily taking the medications that have been prescribed for him. And so what Mr. Pruitt has said is the reports that I've gotten is that he's doing a lot better, and they see a lot of improvement in him. So while we're still waiting on some things, Mr. Pruitt, I ask that you just keep on taking your medications, and that way you can stay focused and clear, so that you can help Mr. Schmidt, so we can get you at some point to where we get your case resolved and get you back home. Okay.
Okay, sir.
All right.
All right. So let's reset just for another status, and I'll ask Ms. Abraham to check in with Terrell State to see what our wait list looks like. And let's set this a little further out. Let's go into April. You know your calendar in April, correct, Mr. Schmidt?
Yeah, I do know that I'm out of.
Yeah, I knew you were out at some point.
Give me just 1 second. I'll pull that.
Absolutely.
What are the dates you have in April, Judge?
What I've got is 4 dates. I got on that first week, I got the 4th and the 6th. And on the last week, I got the 25th and 27th.
Can we do the 25th?
Absolutely. All right, court sets Mr. Pruitt for another status to see how he's doing on April 25th. And then anything that occurs, Mr. Schmidt, that needs to be brought to the court's attention, you let me know if we need to have a hearing before then. And I'll get that information.
Start taking those minutes.
And Mr. Schmidt, before we finalize on Mr. Pruitt's case, do you think, based on your experience with Mr. Pruitt, that maybe with some time, maybe closer to the 27th, that, or I'm sorry, the 25th, that there may be a need to retest Mr. Pruitt?
Yes. Judge, in fact, that's what I was discussing with Mr. Pruitt just then, a request that he maintain his medication. He does appear to be quite a bit better to me. I think that here in the next couple of weeks, if I get some free time, I'll come and pull him and sit down and we'll reevaluate. And if he stays on the right track, then we might be able to make something happen faster.
Okay, and so if he's maintaining competency and you think that he would benefit from another evaluation, then the court would order that immediately, and that way, if he's in a position where he has competency, we can move forward with the resolution.
Sounds good, Judge. That's what we'll do.
All right, thank you, gentlemen. We'll see you soon.
Thank you, sir.
You're welcome, Mr. Britt. Need some more time?
No, we're ready.
Okay, who do you have with you?
That's Hernandez.
Mendez?
Yes, sir.
All right, Esteban Mendes, CR 22, 400 and 401, set for pretrial. Go ahead, Mr. Schmidt.
It is, Judge. On as the court may or may not recall, on the earlier case, we previously announced already, I think the state, if I recall, I've slept, I think they have took that back to grand jury, amended their indictment, filed a new case. At this point, we have 2 charges. I am not prepared on our pretrial yet. I'd ask for another pretrial setting. I anticipate meeting with Ms. Heisel and putting Mr. Mendez's case on my list to discuss with her on Friday.
Okay, the court will grant Mr. Mendez additional pretrial setting on March 7th at 1:30.
That's all right. Slows down. Sometimes. Okay, if not, then I will use it. Clear.
Are you ready now?
I believe Aaron Alvarez is my last one. We're ready for a plea, Judge.
Okay. Mr. Alvarez, come on up, sir.
Yes, sir. So we're ready? Yeah.
All right, this is in cause number CR 22-260, -261, -262, -263, -264, -265. State versus Aaron Alvarez.
And Judge, we're prepared to go forward on a plea on CR 22-265.
Oh, let me see. I think I have paperwork here. Perhaps. I do not think I have paperwork on Mr. Alvarez. I think what I do have is I have the agreed, see, I believe I have the victim impact statement. I also have the agreed protective orders. So if Mr. Schmidt, if you will read me into the plea agreement, and you
Sure, Judge.
said which cause number was that?
265.
265. All right, I'm ready. Go ahead.
Judge, the state's agreed upon a plea of guilty that, to recommend to the court that Mr. Alvarez's punishment be assessed at 12 years in the Texas Department of Criminal Justice Institution Division. He'd be assessed a $2,000 fine, $290 in court costs, $20 reimbursement fee. He's got 251 days credit towards that sentence. In addition, the state has agreed to take under consideration under section 1245 a host of indicted cases as well as some unindicted cases, which are all outlined in the judgment. And we have also executed admissions of unadjudicated offenses and motions to dismiss on those indicted cases. If the court needs me to read all of those from the judgment, I can.
No, that's okay.
Okay. In addition, Judge, Mr. Alvarez has been provided with a copy of Chapter 62 and the supplemental admonishments, which we have executed. We also have in our possession the signature page on the two agreed protective orders that were filed by the DA's office, and I've attached those to the plea pack.
Great. Thank you, Mr. Schmidt. All right, Mr. Alvarez, sir, if you'll raise your right hand, I'm going to place you under oath.
This one, right.
Mr. Alvarez, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I swear.
Thank you, sir. You can put your hand down. All right, Mr. Alvarez, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney?
Yes, I am.
Do you feel like you've had enough time to talk with Mr. Schmidt about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
I understood everything.
Okay. Mr. Schmidt, do you believe Mr. Alvarez to be competent today?
I do, Judge.
And you've explained to him his rights regarding this case and the plea agreement?
I have.
And do you believe he understands his rights and that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir.
All right. And Mr. Alvarez, and let me ask Mr. Schmidt, is Mr. Alvarez pleading? My docket says sexual performance by a child under the age of 14, a first-degree felony?
That is correct.
Okay. Mr. Alvarez, do you understand that that charge, a first-degree felony offense, carries a range of punishment of not less than 5 years or more than 99 years or life, and a fine not to exceed $10,000? Do you understand that range of punishment?
Yes, sir.
And you heard Mr. Schmidt read to me the plea agreement in this case, which was you would plead guilty to that crime, and the state would recommend that your prison sentence be 12 years in prison plus fine, plus your court costs, reimbursement fees. You would get 251 days credit for the time that you've been in jail towards this 12-year sentence, and the state would be dismissing several other cases that are reflected there in the judgment. Is that your understanding of the agreement?
Yes, sir. I understand everything.
Okay. All right, Mr. Alvarez, then let me ask you at this time, how do you plead to the first-degree felony offense of sexual performance by a child less than 14 years of age?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, I am.
And has anyone threatened you, forced you, or pressured you to plead guilty today?
No.
Court accepts Mr. Alvarez's plea of guilt. Mr. Schmidt, any objection to the evidence supporting the state's offer?
Objection, Judge.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, we would just, for the record, like to note that there was a victim impact statement submitted for this case, and we would ask the court to take judicial notice of that at this time.
Right, the court has reviewed the victim impact statement. And the court has considered that in consideration with the plea agreement today. Also has a copy of chapter 62 been provided to Mr. Alvarez as part of the plea agreement.
Yes, sir.
All right, anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, and Ms. Heisel, can you give me a brief summary of the facts supporting the plea?
Yes, Your Honor. In May of last year, I'm trying to remember if she was at the junior high or the middle school in Wills Point, but either way, I believe she was 12 years old, girl came forward to the Wills Point Police Department, reporting that another teenage girl on the app Snapchat was essentially blackmailing her, threatening her into taking certain photos of herself, and that there was another girl at her school. I believe that girl was 13 years old that was also involved with this, who they believe to be teenage girl. Wills Point began an investigation that resulted in several search warrants being issued that ultimately led them to Mr. Alvarez's residence in another jurisdiction. They collected digital devices and did forensic downloads of those devices, which led to information confirming that Mr. Alvarez was the suspect who was posing as this teenage girl online to blackmail these other teenage girls into sending compromising photos and videos of themselves.
Thank you, Ms. Heisel. Any objection to that summary, Mr. Schmidt?
No, Judge.
Okay. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Mr. Alvarez of this offense. Court, having considered the evidence and the victim impact statement, the court will follow the plea agreement in this case. The court hereby convicts Aaron Alvarez of sexual performance of a child less than 14 years of age. The court assesses his punishment at 12 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,000 fine, $290 court cost, $20 reimbursement fees, and awards Mr. Alvarez 251 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Alvarez, you're hereby remanded to the, well, let me also say the court will take into consideration and dismiss under section 1245 those cases reflected in the judgment as agreed between the state and the defense. And Mr. Alvarez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Have you step over with the deputy to be fingerprinted. Mr. Schmidt, let's go ahead and call CR 21276 Ryan Adam Augenstein. I have that he's verified in custody in Dallas County. Do you have any updates on that?
No, Judge, I do know that previously he'd been on the trial docket. We had attempted to bench warrant him from Dallas to enter a plea. Dallas refused to honor the bench warrant, so we are still here waiting on his resolution of Dallas business.
Okay. All right, then let's set him out. Are you available on March 28th?
I think so. Yes, sir, that's fine.
All right, we'll just put in for status of Dallas custody on March 28th, and we'll see what happens between now and then. And if either one of y'all get any information, if you want to let Ms. Abraham know, that I'll notate that docket so I don't have to ask you.
Okay, sounds good. I think that's all we have.
Mr. Schmidt, with respect to the agreed protective orders for Mr. Alvarez's case, the court has everything included in the filing except for that back page signed by you and Mr. Alvarez. So
that's what I was relaying to the court. That's included in the packet. We've signed those and they're attached to the back of the plea document.
fantastic. Thank you.
Okay.
All right, thank you all, counsel. Appreciate it. I think that concludes the court's afternoon docket. If there's nothing further, then we'll be adjourned.
Thank you, Judge.
All right, thank you all.